In the summer of '96,
I have a message for you from the future!
not the summer of '69, made famous by singer Bryan Adams,
The summer of '69.
which was actually performed at Wembley live in the summer of '96. In all of human history, how come there are only two famous summers? The summer of '69 and the summer of love. If summers were named, the summer of '96 could be named the summer of cybersex, at least within the following story. The internet was brand new.
With the A and then the ring around it?
At?
See, that's what I said. Katie said she thought it was about.
Yeah.
Internet chat rooms had just been invented, so people were excited to try them out. And occasionally, the news was buzzing about how two people fell in love on the internet, and now they're getting married. Back then, the tables were turned. The world was like it was opposite world.
What is this, opposite world?
Yeah, right? This is not opposite world.
That means...
God, okay, this is opposite world.
You heard me. Do not go in there.
Why?
Lana, I said no.
Okay, so where's the...
Worst day ever.
Okay, mother in there?
No.
Carol, Cheryl.
And neither is Lana.
Nice. Excellent job. Ow! I mean, totally shit job?
Thank you.
Because most people on the internet were actually decent, and they were actual real people, while scammers were in the minority. Today, it seems to be the other way around. Like, everyone everywhere is out to scam you.
Here's a chat room. Men who like young boys. I'm a young boy seeking an older male for good times. Wow, look at all these guys that want to be my friend.
But in the time of AOL, chat rooms were full of adults, many of them looking to flirt.
She's seeking men, women, Mexican, Indian, black, Asian, group sex, public sex. Good Lord. Anal piss play? Sweet mother of God. Damn. Mrs. Bain. Good Lord. I gotta send this bitch a boner request.
No one had a camera phone, so nudes and selfies weren't even invented yet. If you wanted to send nudes, you had to do it with a Polaroid and via the post office. The popular form of internet porn was fake pictures of celebrities whose heads were superimposed on images of porn stars.
What the hell?
I mean, so I've heard. 20-year-old Jamie Rzucek and Oliver Jovanovic first met after chatting in an AOL chat room. On that night, Rzucek says she endured unimaginable torture. She said that she was tied up, blindfolded, that hot wax was dripped on her breasts and genitals. She also made allegations that include sodomy, painful bites, and threats of being dismembered. After Rzucek reported the assault, the case exploded into a media frenzy, and it became known as the cybersex torture case. Beneath the headlines, the whole case came across as, "See, we told you that people on the internet are going to murder you, and that chat rooms are evil." Below the surface was an unspoken moral panic, like a smug, patronizing undertone from the so-called grown-ups in charge. Assistant District Attorney Linda Fairstein.
She was perhaps the best-known sex crimes prosecutor in the country, Linda Fairstein, stepping down. So is Fairstein paying a price decades later?
The city had settled, and the men were living new lives. But now this TV show has renewed anger, and now there are renewed demands on who should be held accountable. Former New York City prosecutor Linda Fairstein is facing a mounting backlash.
Our case is they're all guilty.
in how her office handled the prosecution of the Central Park Five. It led to the convictions of 5 young men on rape and assault, but all 5 were later exonerated after serving years in prison, and the real suspect later confessed. And today, the public advocate and activists demanded that Manhattan DA Cy Vance review all of Fairstein's cases. DNA evidence exonerated the Central Park Five. They sued New York City for malicious prosecution. The city settled for $41 million. Incredibly, Fairstein says the 5 still had something to do with the...
Those young men admitted to some part.
Linda Fairstein, we don't forget you, we won't forget you, and you will pay for what you did to the exonerated 5.
Yes, that Linda Fairstein said in a statement, Yovanovitch and the victim found each other on the internet about 2 weeks before in something akin to a chat room. They met for dinner, and afterwards, Yovanovitch suggested they watch a movie at his apartment, and the woman agreed. She told police that the movie was about a killer doll or puppet. When the woman said she wanted to leave, Yovanovitch began the torture. And did not release her until 10 p.m. the next night, Fairstein said. She told police that she pleaded for her life, saying, "Please don't dismember me." Okay, hold up. When I read that quote, I just thought it is such a weird thing to say.
What do you mean?
Please don't dismember me? That doesn't even sound real. If you were afraid for your life, you're not thinking, please don't dismember me. You're thinking, please don't kill me, don't hurt me. When I first came across this case, while I was reading her testimony, and that is an actual quote, I just found it odd.
It sounds like a badly written horror film.
Exactly, it sounds fake. Or forced.
I don't think I've ever heard anyone say dismembered in real life.
But it's not just the word. Some people, like someone posh, might have a broader vocab. And she was a college student at the time, Columbia College, I think. I can't remember where she was studying. But if you're being burned and electrocuted with 2 stun batons, and you're terrified, adrenaline is kicking in, your concern right now would be what?
Escape. Shouting for help. Begging for your life. You don't have to do this. I won't tell anybody. Just let me go, please.
Exactly. Your primary concern is to get to a place of safety, not making funeral arrangements.
Like, I want my body to remain in one piece so we could have an open casket.
To me, that sounds like something you'd say. Now, I'm no BDSM expert, but I imagine it sounds like role-playing.
Ah, like, what are you gonna do to me? I've been such a bad girl. Tell me exactly what you are gonna do to me.
Right? Then he was like, first I'm going to give you a spanking. Then I'm going to dismember you.
Please don't dismember me, Daddy.
The woman then described how Yovanovitch carried her to his bed, where he tied her up and started the torture, using 2 baton stun guns like a cattle prod. In April 1998, Yovanovitch was convicted for kidnapping, abuse, and assault. He was sentenced to 15 years to life. When he was interviewed by reporters from the New York Times, it was discovered that the woman did not notify the police for 2 weeks after the date. This might not seem unreasonable on its own, but on the stand, she openly lied to jurors, telling them that she never expressed any interest in sadomasochism. Her own emails told a different story. But the judge in her case would not allow the emails to be entered into evidence. A New York Post reporter interviewed the woman's relatives who shared the story of how, when she was 17, the same woman had falsely accused her father and her uncle of sexual abuse. Her own family said that she could not be trusted. It also came to light that the police did not find any of the 2 stun gun nightsticks with which she was shocked, and that she was examined by a doctor just 3 days after the alleged attack, but no injuries or evidence of the attack was found, which was apparently inserted and then turned on. There was also no bruises, no semen, and no DNA evidence. Some pubic hairs were found in the woman's underwear, but tests showed that it belonged to an unknown male.
Daddy, spank me.
Hello, darling.
Jovanovich's lawyers appealed, stating that the emails should never have been withheld from the jury because they clearly show that the sex between them was consensual, and what she was now calling torture was the 2 of them engaging in kinky sex, which the woman was an expert in, according to the emails. But Fairstein's office argued to have the appeal dismissed, and Judge Wetzel agreed.
The appeal was eventually granted by another court on the grounds of the exclusion of the emails.
In December 1999, Jovanovich was released from prison when the New York Appeals Court ruled that the emails should not have been withheld from the jury, especially the messages in which she describes herself as a pushy bottom, meaning a submissive person who pushes the dominant partner to do what she wants. And in another message, she calls herself a slave who loves to please her master. Yeah. Turns out she had a boyfriend at the time, her master, and she was supposed to meet him on the very night that she spent with Jovanovich. So when the boyfriend asked her why she disappeared for the night, showing up smelling like candle wax and fornication, guess what her excuse was?
I was kidnapped.
Right. Fairstein's office went to the highest court in New York in order to reinstate the conviction. But in July of 2000, the High Court affirmed the appellate court's decision, refusing to reinstate Jovanovich's conviction. But in what's known in the legal profession as a dick move, the Manhattan District Attorney's Office, that is, Fairstein's office, announced that they would retry him. Double jeopardy does not apply when a conviction is overturned due to the defendant not receiving a fair trial. Jovanovich called it a case of vindictiveness. He became further outraged when he learned that the same judge would again preside over the new trial. Fairstein again offered him a plea deal. If he pleaded guilty, he could go free for time already served. He spent 20 months in jail, during which time he survived an attempt on his life and ended up in hospital with cuts to his neck. By then, public opinion had turned on Fairstein's office. He refused, saying, "Even though I know firsthand the horrors of prison, I will never admit to a crime I didn't commit." This case had already become a textbook example of what happens when prosecutors, who are devoid of human decency and empathy, together with a judge who has shown himself to be biased and bordering on incompetence, try to make some sort of moral or political statement by trampling over the rights of ordinary citizens in the process. The Manhattan District Attorney jumped at the opportunity to go after a new kind of criminal that they've been warning people about for a long time: the online stranger. According to the prosecution's storyline, Jamie Rusick was a naive, unsuspecting Barnard College student who stumbled into an AOL chat room, met a cyber fiend, and was lured to his apartment where she endured 20 hours of sick, perverted sexual torture. It was the very first case of its kind. But this portrayal of her as an innocent virginal type was far from accurate. In reality, Rusek was deeply involved in sadomasochism. She was a regular at New York's notorious BDSM clubs like The Vault and Hell's Fire. In fact, it was Jovanovic who was the nerd. He was a week away from earning a PhD in molecular biology and was a world-class chess champion. To secure a conviction, the prosecutor needed to hide the woman's history from the jury. So they used New York's rape shield law, a law that was supposed to protect the sexual history of victims in sexual assault cases. Judge Wetzel agreed and barred the jury from seeing Rusek's emails and chat messages to Jovanovic, in which she openly boasted about her sadomasochistic lifestyle. The jury was kept entirely in the dark about the complainant's background and character. Esteemed publications like the Wall Street Journal and the Boston Globe openly criticized Judge Wetzel's antics. The New York Post, not mincing words, dubbed him Wacko Wetzel. When Judge Wetzel ultimately sentenced Jovanovic to 15 years in prison, the public was outraged. Jovanovic's family and friends spent $500,000 on his legal defense. In prison, he shared a cell block with the infamous Son of Sam, and the two became friends. The state had no hope of winning, not with the inclusion of these sexually explicit emails and the witnesses who signed up to give testimony against her. Even her boyfriend, by then her ex, had signed up to give testimony for the defense. Judge Wetzel refused to recuse himself from the case, despite sharp criticism from the higher courts. The legal struggle dragged on for 2 more years until he finally stepped aside and the case was reassigned to a new judge who quickly dismissed it.
A lesser-known fact is that after the police initially investigated the case, they concluded that it was a bogus case. It was Fairstein who overruled them to take the case forward and press charges. Now, given the police's reputation for being wrong, that doesn't say much about the case itself, but it does give insight into the DA's motives. Perverts luring innocent young girls on the internet? This was sure to be high profile. Being first to convict an online psycho pervert would be great for her reputation and career as a true crime author. And as for Judge Wetzel, this was the era of reality TV, fresh after the O.J. Simpson trial. Judges were being cast into the spotlight and became famous. Judge Judy had premiered just the year before. He thought he could make a name for himself, but instead he became a joke. Linda Fairstein retired a month after the case was thrown out in 2002, which was also the year when the wrongful convictions of 5 teenagers were overturned after a serial rapist confessed to the crime in the Central Park 5 case. So once again, having retired a few months before, she escaped justice and accountability.
The damage done by the prosecutors and the judge was tremendous. A case that should never have been filed consumed 5 years of a man's life and $500,000 in lawyer's fees. Oliver Jovanovic could no longer compete in tournament chess. In 1997, he was just a week from attaining his PhD in molecular biology. It's not as if he could just pick up from where he had left off. Meanwhile, Jamie Rusek was crowned the undisputed cyber sex torture queen and had lucrative movie deals waiting in the wings.
In 2002, the New York Post reporter wrote, "If the district attorney's office had its way, Oliver Jovanovic would still be serving 15 years to life in a maximum security prison. While the DA's office tried to grind justice to a halt, guess what happened yesterday? He graduated from Columbia University as Dr. Oliver Jovanovic. Not only is he now a top microbiologist, but he scored among the top 10 in the entire state. Yovanovitch did submit a lawsuit against Linda Fairstein and Judge Wetzel for malicious prosecution, but it was unsuccessful because he missed the deadline for claims by a day or two. I mean, can you blame him? He was busy preparing his legal defense in order to not be given a life sentence by the diabolical judge and these slimy prosecutors. Fairstein's district attorney's office had access to all of the emails, to all the new evidence that was being exposed by journalists, and still, at every appeal hearing, they were there arguing to keep him locked up. They went after him even after he was set free, and then offered him his freedom if he signed a plea deal saying that he was guilty. What would you do in such a situation? Plead guilty and go free? Or go to trial and risk a life sentence when you just got out of prison after being stabbed in the neck? Some wonder how an innocent person can end up pleading guilty to a crime they did not commit.
When I finally got to the court, this attorney, he came in and told me that the prosecutor office had a plea agreement for me. I'm like, plea agreement? I didn't even do it. You know, I pled not guilty. I'm innocent. He was like this urgent. He was this pressure. And he was like, if you don't take this deal, they only offer you 2 years. You'll be home in 2 years. And if not, you know, they're gonna take it off the trial and the judge is ready to give you a life sentence if you get found guilty. And I think you're gonna get found guilty. And this is my attorney telling me, this is the one person I had was there to help me. So I thought that to get home to my son, then my family, and to salvage my life, that the best thing I could do for myself was to plead guilty and fight it once I got home.
This is how prosecutors coerce people into accepting plea deals. Take the 1-year jail sentence or risk 20 to life by going to trial. And if you can't afford a good lawyer, you are screwed.
The most powerful person in the courtroom is the prosecutor. It's not the judge. Prosecutors are now a peer alongside the judge, and in a lot of ways, they have power instead of the judge. So one day I was in this specialized gun court in Brooklyn. This 19-year-old, he'd gone to a special program, he was getting his GED, and the judge wanted to let him off the hook. She said to the prosecutor, can you lower these charges? Because I really don't want to send this guy to prison. And the prosecutor said, sorry, no. The judge didn't have any choice. He ended up going to jail. It's prosecutors, not judges, who are making these key decisions.
Prosecutors hold so much power that even having a good lawyer might sometimes not be enough.
Days ago, and it made me tear up because he looks, I mean, he is so young and so innocent, and you can really feel that because that is that point. That was the day. Being a pretty normal 17-year-old to never having freedom again. You know, that was captured on TV, and it's like, yeah, it kills me.
Because this case was so clear, so clearly innocent. It just goes to show how completely disassociated the law is. To our great surprise, the US Supreme Court agreed to hear George's case.
The next stage in this lengthy legal marathon would only take place after at least 2 years. It annoyed the legal authorities enough to finally decide to put a complete stop to this case. The state attorney general approached Emily with a radical plea for George. If he agreed to sign a confession for the murder of his best friend, he would be released immediately. George had already been in prison for 30 years.
For George Toka, they offered him his freedom in exchange for him abandoning his quest for justice. If he confessed to the crime, they would allow him to walk out of prison that very day. The other option was that he stay in prison until he gets a new trial, prove his innocence, and then wait to be freed, because they don't even just let you go after you prove your innocence, you know?
and only then sue the people who put him there, getting justice that was long overdue.
George had to make the decision then. Do I accept this or do I stay in jail while my case flows through the legal system?
It was a very hard decision for George. It was really hard for him to do. He did not want to plead guilty.
Place yourself in the mind of a prosecutor. Would you offer a violent killer his freedom in exchange for him to admit that you are the winner? It's clear that this deal was meant to cover their ass. If George eventually does get another trial, it might show that you screwed up, that you were responsible for sending an innocent man to prison. And it could mean that the city would have to pay millions of dollars in compensation. The equivalent would be a madman kidnaps and tortures you for years, then tells you that if you signed a piece of paper stating that you were not kidnapped and never tortured, they would let you go free. And this is the important bit. Once they let you go to the cops to report the ordeal, and the cops say, "You signed a paper saying that you were never tortured," while you still have the clamps hooked up to your scrotum. "There's nothing we can do for you, sir." What do you think George decided to do?
The judge asked him, was he okay with this plea? And he dropped his head and he cried.
The whole courtroom was silent and wrapped with attention, and it's not fair that he had to stand in that courtroom and accept guilt for something that he didn't do.
Everyone in the courtroom was crying. 30 years in jail was enough. To stay another day was a day too many.
It's not fair that he had to say all of that to be freed when he shouldn't have been there in the first place.
Really hurt from having to do that, and excited at the same time that I would actually be getting out of Angola.
George went to prison at 17. He was released at 47. By signing the plea bargain, George accepted to never be officially found innocent for his best friend's murder and never to receive any compensation.
What do you do if the truth is not enough? If being innocent is not enough? The goal of the justice system should be to get to the truth. But to navigate the legal system, it costs so much money that the majority of us can't afford to hire a lawyer to ensure that the proceedings are fair and unbiased. Meanwhile, if you ever find yourself being accused of a crime, the team that you have to come up against are from amongst the most expensive lawyers that money can buy. Their budget is unlimited. The cops are on their side. The evidence collected by the cops makes a beeline straight to the prosecutors. The prosecutors then get to decide what evidence is relevant and what's irrelevant. And whatever more the prosecutors need, they can just ask the police to go and get it for them. While you, on the other hand, only get to examine the evidence on the day before the trial.
Something incredible happens on the day of trial. Suddenly, a case file that for a year was this thick, suddenly now becomes this thick. This is what we are given when DAs answer ready for trial. And the reality is that too often, it is trial by ambush.
No cop is listening when you tell them to investigate other avenues and possibilities. Your lawyer is court appointed, and he really does not want to be there. And yet we're all somehow fine with that. So many of us are still in the dark, naively believing that only guilty people end up in handcuffs. And if I didn't do anything wrong, I have nothing to worry about. Fairfield basically threatened to put this guy in jail unless he admit that they've won the case. If he did that, they would leave him alone. Is that justice? Because to me, it sounds like a shakedown. She just really had to have the win, which is part of a pattern of behavior among prosecutors. Whenever you hear about a verdict being reversed in these cases, there's always a bunch of prosecutors willing to try the case again.
I took this case because I believe that Lamar Johnson's innocent.
There was no physical evidence at all connecting Lamar Johnson with the murder.
This is a rather historic moment. This is the first time where the court is hearing an actual innocence claim filed by a prosecuting attorney.
Lamar Johnson and his legal team gathered in a St. Louis courtroom for a week-long hearing.
New evidence that will exonerate Mr. Lamar Johnson.
There's something powerful when the prosecutor says, we're the ones who made the mistake. We're trying to free this man. Free Lamar Johnson!
How did Marcus die?
Me and Philip Campbell killed him on his front porch.
They put him in that lineup. Yeah. Could you identify anyone?
No.
Altogether, Elking viewed that lineup 3 times and never picked Johnson.
I felt so bad. All that came out of my mouth was like, you tell me what the numbers were and I'll tell you if they were correct. He says 3 and 4, and I was like, you're right.
The Missouri Attorney General's office sent a team of their own to argue that Johnson's conviction should stand.
Good morning, Your Honor.
Who exactly are these people? I want someone to ask them just one question. What the f*** do you think you were doing? Is this some sort of sick joke to you? Okay, that's 2 questions, but if this were my aunt or sister or cousin, I'd be on the phone right now asking them what the fuck is wrong with you. You know, if cancel culture was actually useful to society, these would be the kind of people to cancel, instead of goddamn celebrities who say stupid shit on Twitter.
They provided us with this written statement that read in part, the Attorney General's office has fought to keep a convicted murderer in prison.
Just go f*** yourself. It would take you just 10 minutes to sit with the evidence and conclude that Johnson was innocent, instead of releasing him immediately and apologizing for keeping him in prison for 30 years. No, begging for forgiveness and trying to make it up to him and his family. Instead of doing that, you try to keep him locked up and pretend that your messed up system didn't fail him. For what exactly? What exactly is your goal here? Because there's absolutely no way in hell that you truly believe that he is guilty. I'm not going to speculate on why right now. That is covered in the next one.
They're going to ask you to believe convicted murderers and gang members. Their evidence is not credible.
There's always a bunch of prosecutors willing to try the case again, many times against the public's wishes. In the case of Curtis Flowers, the same prosecutor tried him 6 times after his conviction kept getting overturned. The prosecutor in that case was found to be excluding jurors on the basis of race. He also bribed witnesses with cash payments to say what he wanted them to say.
Curtis Flowers has been tried for murder 6 times by the same district attorney in Winona, Mississippi. Today, Flowers posted bail and was released from prison for the first time in 23 years.
10 minutes after it happened, they zeroed in on Curtis and never looked nowhere else.
Doug Evans used 36 out of 36 strikes to get rid of African-American jurors.
Intentionally dismissing black jurors for no reason other than that they were black. Evans had a history of this during his time as a prosecutor. Evans said he stands by his actions and still believes Flowers is guilty.
You'll find that's a common trait amongst prosecutors and law enforcement.
She has remained steadfast in her belief in the guilt of the Central Park Five.
But she says she has nothing to apologize for. That's the
if you look at Linda Fairstein and if you look at some of the prosecutors, they think that the city should never have settled that case.
Being unable to admit that they were wrong and refusing to accept responsibility for their actions. Instead, they will double down and keep digging themselves deeper, twisting the truth just to dodge the shame.
until their story collapses under its own absurdity.
I think he's wrong in that the system did not fail Mr. Ford. The system,
How can you say that?
because he's not on death row.
Getting out of prison after 30 years is justice?
Well, it's better than dying there.
Dale Cox is talking about Glenn Ford, who they locked up for 30 years for a crime he did not commit. He argues that the system works because Glenn Ford was released from prison 30 years later.
I think he has gotten delayed justice.
There have been 10 other been exonerated. The system is not flawless. Are you sure that you've gotten it right all the time?
I'm reasonably confident that I've gotten it right.
The state was convinced that Mr. Ford was guilty.
Yes.
He could have been killed.
Yes.
And it would have been a mistake.
Yes.
You're saying that's just a risk we have to take.
Yes.
He also says that Glenn does not deserve to be compensated for the time he was locked up.
It's not a question of guilt or innocence. It's a question of whether he's entitled to money. I'm not in the compassion business. None of us are in the compassion business. So to suggest that somehow what has happened to Glenn Ford is abhorrent, yes, it's unfair, but it's not illegal.
You don't think he deserves compensation?
I think that the law must be followed.
Glenn passed away due to lung cancer just a few months after being released.
3 weeks after we met him, Glenn Ford died, penniless. Donations covered the cost of his funeral.
I'm not in the compassion business. None of us, prosecutors or defense lawyers, are in the compassion business. We're in the legal business. Yes, it's unfair, but it's not illegal.
Innocent Project, but they were on the ball. Every time they, came up with new evidence, shut down, peeled it was shut down. Like, how can that be so?
Because this case was so clear, so clearly innocent. It just goes to show how completely disassociated the law is.
During their investigation, Emily and Kristen uncovered every single flaw in George's 1985 defense. They very quickly discovered the name of a young man who supposedly confessed at the time.
If the lawyer had asked some basic questions of George in the community or of Eric Batiste's family, I think he would have very quickly come to the last name of the real perpetrator in this case, who was Edison.
We found all of this evidence primarily talking to witnesses. And the last everyone had seen of Eric Batiste was he was with Edison. And Edison fits the description of the gunman perfectly. He confessed to them about having accidentally shot his friend Eric.
George Toker doesn't match the descriptions given by the only two eyewitnesses to this crime.
Pleadings that we had filed in front of a judge, it's stacked up to probably, something about this high. And the judge heard the arguments and then went into chambers and came back and then essentially said, if I remember correctly, he really didn't find any of the witnesses credible and therefore was denying George the opportunity.
We really had like 10 witnesses in there, didn't we, over the day? Which is quite extraordinary because, of course, the idea that like 10 different people or however many it was would come in for someone who has no power to do anything for them whatsoever, it's really quite astonishing, and it's a pretty worrying attitude that the representatives of the state of Louisiana have.
And I went out into the hallway and cried. That statement by the assistant district attorney is sort of freeing one of their own, and the general disrespect towards to the witnesses.
Yes, the witnesses were all black, and the prosecutor actually said to the judge they were trying to free one of their own. The witnesses included family members of the victim, Eric, who was George's best friend. And for the prosecutor to openly say that to the victim's family, to the witnesses, and the judge agreed? That makes me check the date just to be sure we didn't accidentally time travel back to 1965.
Have you ever had something happen that was so racist that you didn't even get mad? You were just like, God damn, that was racist. Like, almost like it didn't even happen to you. It was like a fucking movie. Like you was watching Mississippi Burning. Wow.
Prosecutors aren't held accountable. We've seen enough examples where some prosecutors don't play by the rules. Because of prosecutorial immunity, which is the doctrine that prevails in this country,
Prosecutor Claude Stewart had committed a serious violation by not telling the court where a key witness was. And Johnson was convicted for the murder.
I understand you want justice. Everybody does, but you should want the right person to be in jail.
Rios also asked Prosecutor Stewart if he knew the whereabouts of Shanice Knight. Again, Stewart said he did not know.
My lawyer, he said, we need time to find this witness. Judge Rios said, we're gonna proceed. Justice Rios knew.
Prosecutor Claude Stewart did know where Knight was. He was lying to the court. Prosecutor Stewart had just committed one of the most common and potentially damaging forms of prosecutorial misconduct. Leroy Van's neighbor, Shanice Knight. She told police that she saw the killers and that Tyrone Johnson's photo did not match any of them.
The gentleman that I seen killed Leroy was not Tyrone.
She also says that Claude Stewart himself had come to her job 4 days before.
2 detectives came to my job.
What did they say?
They stated that if I was lying, that was perjury, 5 years. They tried to intimidate me.
She can discredit the key testimony from the prosecution's alleged eyewitness. Hanley was in her basement, asleep with his girlfriend, when the shots were fired, and she woke him up to tell him.
They're able to file an appeal based on that, and the whole thing just blows up.
More of Prosecutor Stewart's case started to fall apart when Johnson's private investigator interviewed Henry Hanley. Hanley recanted his testimony, saying that after being arrested for a probation violation, detectives pressured him to identify Tyrone Johnson. Then Assistant District Attorney Stewart coached him to make sure his story matched the prosecution. It wasn't the first time.
They find that 5 years before, he did something very similar in a different case.
And he was like, if you don't take this deal, they only offer you 2 years. You'll be home in 2 years. And if not, they're going to take it off the trial, and the judge is ready to give you a life sentence if you get found guilty. And I think you're going to get found guilty. And this is my attorney telling me. This is the one person I had was there to help me.
Rodney Roberts was pressured into accepting a plea deal when prosecutors told his lawyer that the 17-year-old victim identified him in a photo lineup. The victim later denied ever identifying him. He was told that he could be paroled in 2 years if he accepted the deal. He was sentenced to 17 years. Every time he came up for parole, he was denied on the basis that he was a violent sexual predator who forced the young woman at gunpoint. He ended up serving 17 years and was only freed after the Innocence Project helped him get the DNA kit tested, which proved he was innocent.
Those young men admitted to some part.
I didn't see a lady or hit anyone.
Raymond saw you hit her!
Who's Raymond?
Since the Netflix series debut last Friday, the backlash against Fairstein, now an author, has exploded as a single-minded prosecutor convinced of the young men's guilt.
Discarded her like a
piece of garbage.
Why this is directed more at Linda Fairstein is that she has remained steadfast in her belief in the guilt of the Central Park Five.
Admitted to some part of either striking Tricia to bring her down to enable the sexual assault, holding an arm or a leg.
This attitude shows exactly what goes on behind the scenes of these investigations. What she is saying now, she wasn't saying in court. That is not what they presented evidence for during the trial. What it shows is that they, the cops and the prosecutors, they have this attitude of, even if he is innocent of the crime, he must be guilty of something, so just lock him up. In court, they argued that it was a gang activity, that they all took turns while the woman was unconscious. If she truly believed that those kids were holding an arm or a leg, why didn't she make that argument in court? DNA proved that there was only one perpetrator, a serial offender who later confessed. She's giving insight on how these types of people are able to sleep at night by telling themselves if he's black, he must be guilty of something. And in Fairstein's case, being in charge of the sex crimes division, she may have also thought the same thing about men in general. The only way Jovanovich managed to fight back is by having $500,000 laying around. What about the thousands who didn't have that kind of money at their disposal? Justice isn't blind anymore. It's behind a paywall. One that's out of reach to the majority of us.
And if you're wondering what Fairstein thinks about the case, she talked to the New Yorker back in 2002 and said things like, a kid would say something like a dark-skinned guy who lives on 102nd Street, and these detectives would go out and find him. It was one of the most brilliant police investigations I've ever seen.
Which she said she has nothing to apologize for. That's
The question about the Central Park Five was raised. Where there's smoke, there's fire. Fairstein and her team. But to lay it all on one woman is not enough, because she is not the only actor here. And even in this particular, in the Manhattan DA's office, there is a case where I've been telling people to Google People versus Jovanovic. People should go and research that case. It is another example of the type of dirty work that went on under this woman's. The appellate court overturned his conviction. It seems that text messages were kept out of the evidence when the prosecution was presenting the case, and those text messages clearly show that there was consensual sex between this man and woman. Do you apologize for Central Park Five?
Why do you bring that question up now? It's an interesting time to bring it up. If you look at Linda Fairstein and if you look at some of the prosecutors, they think that the city should never have settled that case. So we'll leave it at that.
The police officers, the judges, the district attorney, these people knew exactly what they were doing. And it does not surprise me at all, because at the time, Donald Trump was a major figure in New York.
But all five were later exonerated after serving years in prison, and the real suspect later confessed.
They were in the park.
Yesterday, Fairstein resigned as a member of the Board of Trustees of Vassar College. There are now calls to boycott her best-selling novels.
Admittedly by Michael Wagner.
I know.
Testified to that today.
He caused her to have her driver's license suspended for at least a few months for nothing. Why wouldn't you? Wait a minute. Did you hear the uncontroverted testimony of this officer?
Your Honor.
During the trial, it came to light that no breathalyzer or blood test evidence was submitted into evidence for an arrest for driving under the influence. The officer never did any blood alcohol test on the driver, yet he wrote in his report that the test showed 0.8% blood alcohol.
Did you hear the uncontroverted testimony of this officer?
When the officer was asked why he recorded a 0.8 blood alcohol level in his report, he said it was an honest mistake. He wrote it by accident. The prosecutor went ahead with the case based solely on the officer's testimony, but the judge wasn't having any of it.
I'm dismissing. I am dismissing this charge. No, I'm dismissing the charge.
Notice the prosecutor taking the side of the officer.
Now that I consider what Officer Wagner testified to and how many times He basically tripped over himself just to arrest this lady. I'm granting the JOA. Then I want you taking him up on perjury. Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is not true.
In theory, prosecutors are supposed to be impartial, not on the side of the police, because when officers do wrong, it is ultimately the prosecutors who decide to press charges and what the punishments should be. Do you think this prosecutor will file charges against police officers who plant evidence, use excessive force, or shoot innocent civilians when she is willing to lie under oath for the police?
You know what?
Their address on file.
You know what?
The state intends to amend
I'm
the
granting.
charge and proceed on
I'm rescinding the sentence.
Because you don't like the state's decision today, Your Honor, on the case?
No, you're not. With no real probable cause, you're done. Your JOA is granted.
The judge throws out the case. JOA stands for Judgment of Acquittal. In a criminal case, the prosecution must sufficiently prove all elements of the alleged offense beyond a reasonable doubt. If the evidence is insufficient, the defendant has the right to ask the court for a judgment of acquittal, or JOA.
The JOA is granted.
Meaning all charges have been dropped.
And the dispute about how to proceed, that's when everything just exploded.
Prosecutors now seem to hold as much power as judges.
I'm not going to participate in this proceeding without the elected county prosecutor.
Don't believe me? This prosecutor throws a tantrum in court and storms off.
A wild scene in an Ohio courtroom Thursday where an angry prosecutor stormed out of court after berating the judge.
She chose not to be here.
That's not accurate, Judge.
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiff...
Your objection is noted. Okay?
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was...
You're going to sit here. You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a...
Well, I'll tell you what. If you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
Because he knows that he cannot be punished. If you want further proof of how prosecutors and judges are too cozy, watch this.
Buckle up, it is one of the cringiest things you will ever see. And not just any judge, a judge on the State Court of Appeals.
This could have been 3 separate...
Okay, but it wasn't 3 separate. Let's go with what happened in the case.
But, honey, oh my God, I'm sorry. I'm sorry, Your Honor. That, I don't know what to say to that. I apologize.
Okay, go ahead.
The question here is what happened. I'm sorry, I've just been totally thrown by
I can
mistake.
imagine. I can imagine. I'm a little thrown by that also, if I'm being honest.
Your Honor, I don't know what to say. It's just a...
Okay, well, go ahead. You've only got 1 minute and 7 seconds left.
The question here...
Of course it went viral, but it also divided us in a big way.
And here, a prosecutor is confronted by a reporter after arguing to keep a clearly innocent man locked up. But he argued to win on a technicality instead of whether or not the man was guilty.
Around the time of the murder took place, Kid was in a sheriff's office applying for a gun permit, which is a pretty fucking solid alibi. When his new lawyers filed that appeal, they failed to include that argument, so the state fought to keep him locked up.
You don't have any concern that a police commissioner and former prosecutor say he's innocent? I mean, according to your name is here right in the court document, and you're not even arguing that he's guilty, just technicalities that he missed his chance to properly appeal. You don't seem concerned about this. Do you even think he's guilty? No answer? I mean, you're spending taxpayer money to fight this case. You're keeping him locked up in prison. Is that the best use of taxpayer money? Y'all have a good day, sir.
Wow.